So in the previous class we started with the discussion of Supreme Court and High Court, right? So simultaneously we started with comparison. So initially we started with the background of historical background of Supreme Court and High Court. So when was Supreme Court established? In which year? 1950. It was established in 1950, right? To be specific, which date? 28 Jan. So before Supreme Court, so which institute existed? Federal Court of India. So it was established through which act? Government of India Act 1935. Next we saw the historical background of High Court as well. So High Courts were established at which place? Which all places? Bombay, Calcutta and Madras. So in which year? 1862. Then we discussed about the various features like composition of Supreme Court and High Court. So who can increase the number of judges in the Supreme Court? Parliament. So presently how many judges are there? 34. Every year it has to be updated. Okay, if there is any new changes, there are any new changes. Next, who can increase the number of judges in the High Court? Parliament or President? It is President. When it comes to increasing the number of judges in the High Court, it is President. Okay. Next, we saw the qualification required to become a judge of the Supreme Court and High Court. Right? So, what are the qualifications required? At least one or two. Citizen, it's very obvious. Okay. Next, he should have served as judge in a High Court for 5 years, or practiced as an advocate in High Court for 10 years. Okay. Similarly, for High Court judge also we saw the qualification. Next, we saw the removal process of Supreme Court and High Court judges, whether it is different or it is same. The removal process same. Who can remove? President. Appointment is done by President. Removal is also done by President, both Supreme Court and High Court judges. Similarly, oath. So whether it is Supreme Court judges or High Court judges, oath is also administered by President. No? So when it comes to High Court judges, so oath is administered by Governor. Okay. Next, we also saw that when it comes to removal of judges of Supreme Court, High Court, the process is not that easy. The process is a bit tedious, right? So it requires the support of both Lok Sabha and Raj Sabha with what kind of majority? Special majority, and it has to be presented to the President in which session? In the same session. Okay, same session. So in the history of India, there have been no instances where a President has been removed. So sorry, where a judge has been removed. Okay. In the history of independent India, no judge has been removed through this process. Okay. Even though some cases have gone, but they have not been removed. Okay, they have never removed it. So again, that historical example also they have mentioned in Lakshmikant. If you go through the book, they have mentioned about the Lakshmikant, in which instance what attempt was made to remove a judge, but there what happened in Lok Sabha, some of the members walked out. Hence, it did not succeed. Okay, did not succeed. Again, sometimes in the examination they may ask in that fashion as well. So in the history of independent India, how many times judges have been removed by this process? Okay, no judge has been removed by that process. Next, after that we came across what the various types of judges like ad hoc judges, additional judges, next acting judges and all. So we saw the difference between Supreme Court and High Court. Okay. So next, here the comparison will end. Now finally we discuss about the jurisdiction. So who can extend the jurisdiction of the Supreme Court? Parliament. Who can extend the jurisdiction of the High Courts? Both Parliament as well as state legislature. Who can curtail the jurisdiction of the Supreme Court? No one. Parliament cannot curtail the jurisdiction of the Supreme Court. Who can curtail the jurisdiction of the High Courts? Both Parliament as well as state legislature. On all the matters? Few matters which are mentioned in the Constitution. Not mentioned in the Constitution. So until this point we discussed in the previous class. So next we shall resume here. Now here we will not discuss with the help of comparison. We will be discussing independently. Okay, we will be discussing independently the features associated with Supreme Court and next High Court. High Court. Jurisdiction and powers of Supreme Court. So it's not a federal court like the American Supreme Court. So Indian Supreme Court is not a federal court like American Supreme Court. So recently we were discussing about the parliamentary system, probably parliamentary system itself, parliamentary system or federal system, I think federal system. In federal system we understood that in America even judiciary is federal. It means the Supreme Court which is present in America, it can only hear cases related to center. That is cases related to center's law. It cannot give judgment on the cases related to state's law. Okay, state's law. It is federal in character. But in India, the judiciary we call it as integrated. Why we call this integrated? Because Supreme Court can enforce both central laws as well as state laws, and similarly High Court can enforce both state laws as well as central laws. So here our Supreme Court is not a federal court like American Supreme Court. Okay, they have never asked a question, but again out of curiosity we need to know. Okay, it's not a federal court like American Supreme Court. It's a final court of appeal like the British House of Lords. So in India, which is the final court of appeal? Supreme Court or British Privy Council? Supreme Court. Previously, whether British Privy Council was the highest court of appeal? Yes. So later on it was removed. Okay, it was removed. Now the highest court of appeal, the highest where you can go is, you can go to Supreme Court. But here again important point, because when it comes to main syllabus, they have explicitly mentioned comparison of Indian constitutional schema with that of the other countries. So we will not be comparing every provision with the constitution of every other country, but whichever provision explicitly it has been mentioned in Lakshmikant, we will focus on it. So here what they have mentioned, final court of appeal like the British House of Lords. So in Britain, again there we have upper house and lower house. Okay, lower house and upper house. In India, which is the upper house? Rajya Sabha. Similarly in Britain, the upper house is called as British House of Lords. So in Britain, if Supreme Court decision, if you are not happy, you can appeal. Whom you can appeal? You can appeal to upper house. Okay, but in India there is no such provision. If you are not satisfied with the decision of the Supreme Court, can you go and appeal to Rajya Sabha? No, there is no such provision. The highest appeal that can happen in Britain is to British House of Lords, whereas in India it is Supreme Court. Final interpreter of the Constitution. So who has the highest power to interpret the Constitution, Supreme Court or High Court? Supreme Court. Okay, Supreme Court is the highest interpreter. Even High Court also interpret, but the highest power of interpretation lies with the Supreme Court. Okay, Supreme Court. Next, guardian of Constitution. So whenever Constitution is being violated or it is being threatened, then it will act as a guardian of the Constitution. Now don't go into deeper aspect what exactly is guardian. Okay, it's a who. Now in the examination they will ask a question. So who among the following act as a guardian of the Constitution? Parliament, President, Supreme Court, none of these. Okay, Supreme Court. Again they will not ask you to demonstrate with the help of an example. So just retain this statement. Next, guarantor of fundamental rights of citizens. So whether it's a guarantor of fundamental rights, yes, whenever your fundamental rights get violated, so where you can go? You can go to Supreme Court directly, or you have to go to first High Court and then itself by appeal you have to go to Supreme Court. So when your fundamental rights get violated, you have a choice either to go to High Court or directly go to Supreme Court. So hence it is a guarantor of fundamental rights as well. Okay, guarantor of fundamental rights as well. So again in the examination they may ask, so which of the following act as a guarantor of the fundamental rights? So multiple entities when they mention, we should be able to identify the entity, that is Supreme Court. Okay. Next, it has some advisory and supervisory powers. So which are those advisory and supervisory powers? We will be looking into it later on. So advisory means when someone is in a confusion, okay, so he will seek advice from the Supreme Court. So who will be having that confusion? Later on we will see the President of India. The President of India, whenever he has some kind of confusions, he will seek the advice from Supreme Court. So at that time Supreme Court will give the advice. Okay, again it comes under multiple parts, we will be discussing later on. Next, supervisory powers. Whether someone is working properly or not, High Courts are working properly or not, that supervision power also lies with the Supreme Court. Okay, lies with the Supreme Court. Now jurisdiction of Supreme Court. So which all cases it can hear, that is called as jurisdiction here in this context. We are not speaking about the territory, we are speaking about the subjects. So what kind of cases Supreme Court can hear? Okay, what kind of cases Supreme Court can hear? So it has been classified into various aspects. So one is original jurisdiction, next writ jurisdiction, appellate jurisdiction, advisory jurisdiction, a court of record, next power of judicial review, other powers. Okay, so now what we will do, so these are the various jurisdiction: original, writ, appellate, advisory, a court of record, power of judicial review. So we will be discussing about these aspects one by one. Okay, one by one. Again the examination they will not ask you which of the following are the various jurisdictions of Supreme Court. Okay, they will not frame such kind of questions. So just we need to know there are different types of jurisdiction, original, writ and all. So I think already we have discussed about one, if you remember. We have discussed about writ during the discussion of fundamental rights. Okay, so you can file a writ either in the Supreme Court or in the High Court whenever your fundamental right gets violated. So it means Supreme Court has the jurisdiction over the matters related to fundamental rights. So that speaks about the jurisdiction. Okay, jurisdiction. Now we'll discuss one by one. First we'll start with original jurisdiction. Okay, so this is repeated. So now this is original jurisdiction. So what does original mean? Okay, original jurisdiction of Supreme Court, a very important topic. So again, when you refer to the previous year question papers, so few questions have appeared on this topic. Okay, few questions have appeared. So disputes between center and state. So whenever there is a dispute between center and state, so that dispute has to be resolved, right? So who has the power to resolve? Supreme Court. Okay, Supreme Court. So can you give me an example of a dispute that can arise between center and state? Yes. Water, generally it will arise between multiple states. Okay. Yes. Border. Okay, border region also it will arise between states. Subjects. Okay, subjects related matter can come for a dispute. For example, center can make a law on state is subject like health. Now states are not satisfied. Some states says that you are infringing our powers. At that time, such cases can be taken to Supreme Court. Yes, you give one more example. Grants. So grants again we are not sure, but taxes we can say. So taxes related to some cases, center and state. So state can file a case against the center, okay, in the Supreme Court. So such cases are heard by Supreme Court. So here it is called as original jurisdiction and exclusive jurisdiction. So both of them they have a different meaning. Original means it should hear first, means the case cannot go first to High Court and then come through an appeal. Original means only directly it should hear. Okay, it should hear. Exclusive means only Supreme Court itself can hear. High Court cannot hear. Okay, cannot hear. Now next when we start discussing about writ, we come across only original jurisdiction, not exclusive. Okay. So here exclusive means when it comes to center state disputes, only Supreme Court can hear, and also it cannot come through an appeal. It cannot come through an appeal, only directly first instance itself it should hear the cases. It should hear the cases. Next, between center and state on one side and states on the other. So in the first example, for example, central government and Karnataka state government. So this is the first example. So second example can be, for example, center and Karnataka, they are fighting on one side and Tamil Nadu is fighting on the other side. Okay. So center and state on one side and state on the other. Two or more states, for example, Karnataka and Maharashtra. So they have a dispute. So these disputes can also be handled only by Supreme Court. So in the examination, what kind of questions can be framed? So dispute between two or more states can be handled by High Court. True or false? False. Why? Because it is exclusive. Okay, it is exclusive. So fundamental writs can be heard only by Supreme Court. False. Because it is original but not exclusive. Okay, not exclusive. So two or more states. Exclusive means no other court can decide. Original means not by way of appeal. Okay, not by way of appeal. So what kind of things it can hear? Question of law or fact. Existence or extent of legal right depends. So this statement will cause you confusion even while going through the book. So you just ignore this statement. Don't focus on this statement. Okay, just don't focus on this statement. So they are not going to go to such a deeper level and check whether you have complete depth understanding or not. Please ignore this statement. Okay. So it will hear cases related to law or fact. If you want to memorize, just memorize these two terms. It can hear cases related to either law or fact. What is law? What is fact? Don't worry about it. Don't worry about it. So it cannot hear political nature questions. Okay, it cannot hear political nature questions. So what exactly is the political nature? Can you give an example of a political nature question? Okay, it will be difficult to connect. Dissolution, okay, not dissolution. So for example, let's assume he mentioned the example for grants. So someone will complain that ours is a BJP ruled state and at the center we have Congress. So they are giving less funds to us and they are giving more funds to other state. So there is no solid base for it. You are just making an allegation because it's of political nature. at the center lies the Congress and at the state lies the BJP. So I am just giving an example, again not important. So maximum what they can focus is whether political nature questions come under the exclusive original jurisdiction of the Supreme Court. No. Okay, no. Private citizen suit against center or state, not covered under it. So private citizen suit, for example, if the road is not being constructed properly, so this is a responsibility of state government. So someone, if he files a case against the state government in the Supreme Court, he cannot file it, it does not come under the original jurisdiction. So can he file a case? Yes, he can file a case, but it does not come under the exclusive original jurisdiction of Supreme Court. Okay. So such cases can be heard by appeal, later on we will be looking into it. So from exam point of view, so whether private citizen suit against center or state, whether it falls under exclusive original jurisdiction of Supreme Court? No. Okay, no. Next, this exclusive original jurisdiction of Supreme Court does not extend to pre-constitutional treaty. Okay, pre-constitutional treaty. For example, we got a constitution in 1950, but before 1950 also there were some kind of understanding or treaties that were reached. For example, let's assume before our constitution there was a state called as Madras, there was a state called as Mysore before independence or before we got the constitution. So let's take the example of Kaveri river itself. Okay, Kaveri river itself. So let us assume Mysuru and Madras state before independence itself, they had an agreement that so and so quantity of water should be supplied to Madras region through Kaveri river. Okay, through Kaveri river. So this is a treaty which existed before the constitution came into force. So when someone will file a case in the Supreme Court saying that this treaty is wrong, I want to correct this treaty. So such cases will not fall under the exclusive original jurisdiction of the Supreme Court. Very important. So pre-constitutional treaty, they do not fall under the exclusive original jurisdiction of the Supreme Court. So treaty explicitly excludes its jurisdiction. Okay. So now after independence also there are some treaties between two states, but in the treaty explicitly they will say that the Supreme Court should not hear such kind of cases. Such cases can also not be taken by Supreme Court. Okay. Interstate water disputes. So here I took an example of interstate water disputes, but the treaty may not be exactly for the interstate water disputes. It can be for other purposes as well. Okay, other purposes as well. So again, interstate water disputes, Supreme Court's exclusive original jurisdiction does not extend to interstate water disputes. So while discussing center-state relations, if you remember, okay, so we discussed that water is a very sensitive subject. So can Supreme Court give a judgment on water related issues? No. So Constitution has given more power to whom when it comes to interstate water disputes? It has given more power to Parliament. And Parliament, by using that power, it has passed multiple acts, enacted multiple laws. Which are they? Interstate Water Disputes Act and next River Boards Act. Okay, River Boards Act. So similarly here, the same we are again recollecting. So interstate water disputes, they do not come under the exclusive original jurisdiction of the Supreme Court. Matters referred to, FC means Finance Commission. So already President has given a matter to Finance Commission. So you work on that. So someone cannot challenge in the court that whatever the matter that has been referred to Finance Commission is not correct, it has to be changed. No. Such cases do not come under the exclusive original jurisdiction of the Supreme Court. Adjustments, expenses and pensions of center and the states. Okay. So again, not important point. Expenses and pensions related to center and states not important. Ordinary dispute of commercial nature, center and state. Okay. Ordinary dispute of commercial nature, again for let's say take a very simple example. Now let's assume a central government property exists in Karnataka. Okay, Karnataka. So now let's assume Karnataka government is occupying that. The building which is present in front of our building. Let's assume it is central government building. Now Karnataka government has taken it for rent. Now, but it is not paying the rent on monthly basis to the central government. So this is what? Ordinary dispute of commercial nature. I just took an example. So such cases Supreme Court cannot take under the exclusive original jurisdiction. Okay. Again, we need to understand the exam's demand also. When we look at the previous question papers, repeatedly it focuses on center and state. Okay, between multiple states. So very rarely it comes across such kind of points. So from the exam point of view, these points do not carry much weightage, especially from prelims point of view. Okay. That exam's demand is also equally important. Recover of damages by a state against center. Okay. So again one example. For example, railway belongs to whom? Central government. So let's assume a railway which is traversing through Karnataka. So there will be an accident. So because of the accident, not only the railway station property will get damaged, the surrounding area, the private property also will get damaged. Okay. Now the residents of Karnataka, they will start claiming against the state government that we want that compensation. Now that compensation state government will give, but it has to take from whom? From the central government. So recover of damages by state against center. Again, such cases, it cannot, if the center is not paying the compensation for the damages, then we have to file a case. So where we will file the cases? Okay, so directly Supreme Court or not. Again, such cases, they do not come under the exclusive original jurisdiction of the Supreme Court. Okay, so first such suit in 1961 by West Bengal government against the center. So whether such a case have ever been filed against the center? Yes. So first such case was filed against the center in 1961 by West Bengal government. Okay, West Bengal government. So the examination they may ask in the worst case, so whether the history of India, whether any cases have been heard by the Supreme Court under its exclusive original jurisdiction. So next is writ jurisdiction of Supreme Court. So here we saw that jurisdiction means Supreme Court can hear the cases with respect to the dispute between the center and the state and state on one side and state on other side. Next, center between states. How about the dispute between the center and the union territories? So this is how the UPSC will focus. The information which is missing here, it will focus a question on that. Who handles a dispute between the center and the union territories? Yes. So a dispute will never arise between the center and the union territories because union territories are directly under the control of the central government. So a dispute between the center and the union territories, it does not fall under the exclusive original jurisdiction of the Supreme Court. Okay, we have to understand. Next, writ jurisdiction of Supreme Court. Okay, writ jurisdiction of Supreme Court. So whenever we say writ, it means we are speaking about fundamental rights or violation of fundamental rights. Okay. So Supreme Court is a guarantor and defender of fundamental rights of citizens. Okay. So don't try to find the exact meaning between the difference between guarantor and defender. Just memorize this thing. It's a guarantor as well as defender of fundamental rights of the citizens. Empowered to issue. So I think we have discussed about the habeas corpus and all during the discussion of fundamental rights. Okay. Habeas corpus, mandamus, prohibition, quo warranto, certiorari. Okay. If there is confusion, I will urge you to go back to the fundamental rights related class to understand in detail about what are these habeas corpus and other writs. So why these writs are issued? To enforce the fundamental rights of the aggrieved citizen, the person who has faced a problem. So he will go and approach the Supreme Court. By hearing his case, Supreme Court will issue various writs. So it may be a habeas corpus, it may be mandamus, or so on. And so on. It is original jurisdiction and not exclusive. This is important. Supposedly writ jurisdiction, if it was exclusive, suppose the writ jurisdiction was exclusive, then what would have happened? Whenever a fundamental right got violated, then what were the chances? Where you should have gone? Directly Supreme Court. There were no chances of you going to High Court. Suppose the writ jurisdiction was exclusive. But now the writ jurisdiction is not exclusive. Okay, it's not exclusive. But it is original. What does it mean? Whenever your fundamental right has been violated, you can either directly go to Supreme Court or High Court. Okay. You cannot come by via appeal to Supreme Court. When a fundamental rights gets violated, you should go to High Court. If the decision given by the High Court, if you are not satisfied, can you go by appeal to Supreme Court? No, because it's original. Supreme Court should hear it at the first instance, not through way of appeal. Okay, very important. So that is the meaning of original. Okay, original. So these things are very, very confusing. Okay, very confusing. Original means Supreme Court will hear it at the first instance, not by way of appeal. Cannot by way of appeal. So why it is not exclusive? Because High Courts in India are also empowered to issue these writs. Already we have seen. Okay. So it means aggrieved can move either Supreme Court or High Court. The person who is facing the problem, he can move to Supreme Court or he can move to High Court, and if he is not satisfied with the judgment of the High Court, then he can appeal to Supreme Court. Yes or no? No. He cannot appeal when it comes to writs from High Court to Supreme Court. High Court can issue writs for other purposes as well. This is also important. I think during the discussion of fundamental rights, whether we came across this point or not, but this is very important. Now, Supreme Court can also issue writs for the violation of the fundamental rights. High Court can also issue writs for the violation of the fundamental rights. Now, apart from the fundamental rights, if any of your other right gets violated, for example, right to property. Let's take right to property. So, during the discussion of fundamental rights, we saw that right to property is a fundamental right. Yes or no? Originally, it was a fundamental right. Yes, it was removed from the list of fundamental rights. Now, can we consider right to property as other purpose or other right? Yes. When your right to property gets violated, can you directly go and file a case in Supreme Court under writ jurisdiction? No, because Supreme Court can only hear writs with respect to the violation of the fundamental rights. Okay, with respect to the violation of the fundamental rights. But can you go and file a case in the High Court saying that your right to property has been violated? Yes, because High Court can issue writs for other purposes as well. Apart from the violation of the fundamental rights, it can also issue writs for the other purposes as well. Okay, other purposes as well. Hence, writ jurisdiction of High Court is wider than that of Supreme Court. Very important. Now, this statement, when they make in the examination, if we do not have the depth of understanding, we often end up marking a wrong choice. So, we come to a conclusion that this statement is wrong. But here, we have to understand that Supreme Court has more powers in all the other aspects. But when it comes to writ jurisdiction, so whose jurisdiction is wider? High Court's writ jurisdiction is wider than that of the Supreme Court. Okay, Supreme. Parliament can confer on the Supreme Court the power to issue other writs as well. Again, this is also important. So now, High Courts have the power to issue writs with respect to other issues. Similarly, can Supreme Court also issue? Yes, they can issue, but that power has to be conferred, has to be given to Parliament. By whom? Sorry, to Supreme Court. Who will give the power? Parliament. Okay, Parliament. Now again, don't go to the detailed aspect whether Parliament has ever given such kind of power or not, whether it has passed any act or not. No. Okay, just we understood that Parliament can give what powers to Supreme Court to issue writs with respect to other matters as well. So, but for High Court, it is by default. By default, it can issue writs for other purposes. Okay, other purposes. Now we saw two jurisdiction. One is original jurisdiction, another one is writ jurisdiction. So these two aspects are very important from exam point of view. The next jurisdiction, that is appellate jurisdiction of Supreme Court, it's not that much important. Okay, they have given so much of content in the book. So every line, sometimes it starts appearing important and sometimes it starts causing confusion. So many times aspirants will be stuck there itself. You will not get stuck there itself. If you are not understanding few of the things, even when you go back, you will not pause there itself. You will just proceed to the next point. That is very important. Okay, because we have to complete all the syllabus, right? So everything which is important from the exam point of view, it should be at the tip of our finger. Okay? Hence, it's very important to ignore the unnecessary things. So appellate jurisdiction of Supreme Court. So appellate means it will hear the cases by way of appeal. So whatever the judgment the High Court has given, so if a person is not satisfied, he will go to Supreme Court. So such cases or such hearing is called as appellate jurisdiction. Okay, appellate jurisdiction. Supreme Court has succeeded the Federal Court of India. So already we have seen during the introduction. So Federal Court of India was established through which act? 1935. Next it was replaced by Supreme Court in which year? 1950. Next we also saw that Supreme Court has replaced the British Privy Council as well. So previously British Privy Council was the highest court of appeal, but now Supreme Court is the highest court of appeal. Classification. When it comes to appeals, it can hear different types of cases. It can hear constitutional matters, it can hear civil matters, it can hear criminal matters. Okay, criminal matters. So let's take one example for each just to understand at the superficial level. So constitutional matters. So let's assume Centre has brought an act called as Agriculture Reforms Act 2025. Agriculture Reforms Act 2025, it has been brought by central government. Okay, Parliament has brought this law. Now this agriculture is an issue which belongs to which government? State government. So centre ideally should not make this law. Now some states are not happy. Let's assume a person in Karnataka, he will challenge this law. Where? In Karnataka High Court. can a law enacted by the central government be challenged in the Karnataka High Court? Yes or no? Yes, because India's judiciary is federal or integrated? Integrated. We have seen they can enforce both central laws as well as state laws. So this is the law made by Parliament, that is center, but now a Karnataka person has challenged this law in the Karnataka High Court, saying that this law, it violates the constitution. Why it violates the constitution? Because it violates the federal structure. Agriculture is a stateless subject, so state should have made the law, but center is making the law. Okay, center is making the law. Now Karnataka High Court, what it will do? It will declare this law as invalid. Invalid and void. Can Karnataka High Court do this? Does Karnataka High Court has the power? Yes, it can declare it. Now what the central government will do? It will appeal this judgment. It will appeal this judgment in Supreme Court. Supreme Court. So now it is called as appeal in constitutional matters. Now again questions will arise. What is that questions? Already we have seen center state dispute, it comes under original jurisdiction. Here it is appellate. What is the difference? We will not go into these exact differences. Now the difference is not between the center and the state. A private person has filed a case against the center saying that it violates what? This law, it violates the constitution, federal structure. So it is not a dispute between center and state. And even if you are not able to connect to such a deeper extent, also just leave it. Okay. So what we have to understand here is Supreme Court's appellate jurisdiction includes appeals in constitutional matters. So this is an example of a constitutional matter. I am just giving an example. Okay. Again, there may be some other examples as well, just to connect and to help us comprehend the things easily. Next, civil and criminal. Okay. Civil and criminal. Okay. So let's assume property related, just at a superficial level. So we will not go like a lawyer into deeper aspects of exact difference between civil and criminal. So civil matter we shall take property related matter, and criminal matter, let's say murder. Murder we shall take it as an example. So let's assume someone has, person 1 has forcefully taken the property of person 2, okay, by creating some documents and all. Okay, documents and all. So this case will go to High Court. High Court. Now High Court will rule in favor of person 2. So it will say person 2 is correct and it belongs to him. Now what person 1 will do? He will appeal this judgment in Supreme Court. So that is the appeal in case of civil matters. Okay, civil matters. Similarly, when it comes to criminal matters, let's assume person 1 has murdered someone. Okay, murdered, or there is an allegation that he has murdered. Okay, he has murdered. Now this case will go to High Court. High Court will declare that yes, he has committed mistake, let us give him 20 years jail or 20 years imprisonment. Okay. So this is a criminal matter. Now this person 1, he will challenge it in Supreme Court. So now Supreme Court will hear this case. This is called as hearing the appeal in case of criminal matters. Okay, criminal matters. Next, appeals by special leave. Now whenever High Court gives a decision, it will produce one more letter saying that if you are not satisfied with our decision, you can appeal it to next court. Okay, next court. But sometimes High Court will not issue this letter. Okay, not issue this letter. So Supreme Court will issue a letter. We are giving a special leave. Whatever cases you have, you can file, appeal to us. Okay, appeal to us. This is called as appeal by special leave. Again, we will be discussing about it later on. Okay. So here, what we understood here is when it comes to appellate jurisdiction exists in case of constitutional matters. Appellate jurisdiction exists in case of civil matters as well as criminal matters. So constitutional matters already we discussed with the help of an example. So against judgment of High Court, if the High Court certifies that the case involves a substantial question of law that requires interpretation of constitution. So again, this line by line information is not important. So after giving a judgment, we took an example of which act? Agriculture Reforms Act. So Agriculture Reforms Act 2025. So High Court will give a judgment on it, and it will say that it also give a certificate saying that we have given the judgment, but the case involves substantial question of law that requires interpretation of constitution. So this case involves interpretation of constitution. Hence, a person who wants to file an appeal, he can file in the Supreme Court as well. But this statement is not important. You need not focus on it. Okay, need not focus on it. So from any judgment of High Court, if High Court certifies, okay. Now here, you don't go into these points itself, because again understanding exams demand is important. Unnecessarily they'll cause you confusion, not important. You have to become jack of all the subjects, okay. So what you have to understand here is, Supreme Court can hear appeals from any judgment of the High Court if High Court certifies. High Court has to certify. What it has to certify, they are given here, not important. Question of law or general importance, these things will cause a lot of confusion. Again, not important from exam point of view, you just ignore these points. Okay, question of law or general importance, you just ignore that point. Criminal matters. Okay. So criminal matters, he has given too much of information. We'll now discuss, but at the time of examination, we'll not go into these detailed aspects. Okay, we have to understand the exam's demand. So criminal matters, if a High Court on appeal reversed acquittal to death, matter of right, no certificate required. So again, to such a deeper level, they have never asked. Okay, they have never asked, but at least we should try to understand what does it mean. So let's assume a district court, High Court, Supreme Court. Okay, district court, High Court and Supreme Court. So person involved in murder, allegations of murder. So what is allegation? What is allegation? It means whatever the charges are there, they are not yet proved. You have just made an allegation. You have just made an allegation. Now the police force has to prove it. Okay, has to prove it in the court of law. So allegations of murder. So that case will go to district court. So in district court, what they will come to a decision is, so let's assume person A and he has killed person B. Okay, so he has killed him or he has murdered person B. Now person A has been acquitted. Person A has been acquitted. So the meaning of acquitted means he has not committed any murder, there are no proofs, so he can go back to his home. He can relax. That is called as acquittal. So in the newspaper regularly when you are reading, so you come across these terms, acquittal. Acquittal means the charges are not proved. He is innocent. He will be sent back. Okay. So no punishment. But when this person is acquitted, whether the family members of B will keep quiet? If they really have a concern for person B, then what they will do? They will go for an appeal to High Court. What they will say? The district court has said that this person has not committed any murder and it has acquitted it, but we are not satisfied. We are coming in the form of appeal to you. Now High Court, what it will do? Again, it will call all the documents. Again, by cross-checking and all, it will give a judgment that this person has committed the murder and he will award him death sentence. He has to be hanged till death. So see here, it's completely reverse. The district court has said free, acquittal, but High Court, death. So here, on acquittal to death, so on appeal reversed. So who got the appeal? High Court got the appeal. On getting appeal, it reversed the acquittal to death. The person who was free, now he has been given the death sentence. So now whether this can be filed, again appeal can go to Supreme Court. Now in this, who will go as an appeal to Supreme Court? Person A or the family members of B? Yes. Because already now he has been given death sentence, the family members of B are celebrating. Right? So who will go to Supreme Court? Person A will go to Supreme Court. Okay, person go to Supreme Court. Now in the previous case we saw that whenever High Court gives a decision, it has to give a certificate that if you want you can appeal to the Supreme Court. Okay. Now in this case, let's assume High Court refuses to give that certificate. It is not right to give that certificate. Can person A appeal in the Supreme Court or not? Yes. Now here it is, no certificate required. It's a matter of right. It's a matter of right. So High Court, after receiving an appeal from the lower court, if it has reversed the judgment from acquittal to death, then that cases can be appealed to Supreme Court without the certificate of the High Court also. Okay, High Court also. Next, taken itself from subordinate court, awarded death sentence, matter of right, no certificate received. The second case is, the district court is still hearing the case of this person A. District court has not yet given the final judgment. In the previous instance what we saw, district court has already given the final judgment. Now the second instance is, let's assume, district court has not yet given the final judgment, still it is hearing the case. In such a scenario, High Court what it will do? It will take the case by itself. The High Court has the power. Okay, it will take the case by itself, and after taking the case, it will award a death sentence to person A. Okay, to person A. In such a scenario also, as a matter of right, person A can appeal to where? Supreme Court. Here also note certificate received. Okay. These are two cases. Third case is High Court certifies that the case is fit for appeal. So irrespective of any case, if the High Court says that, it will produce a certificate saying that this case can be appealed to Supreme Court, then we can appeal. So in the previous two instances, no certificate was required. So here, if a certificate is provided, then also in any case they can appeal. Okay, they can appeal. On appeal, reversed death to acquittal. No right to appeal. Okay, what does it mean? The same case, High Court, District Court, Supreme Court. So District Court has given death sentence to person A. Okay, death sentence to A. Next, High Court has reversed death sentence to acquittal. Now you are free. In that case, who will go to Supreme Court? Now person A will not go to Supreme Court. Probably the family members of B will go. But that no right to appeal. No right to appeal. So it means they should be given a certificate. The family members of B should be given a certificate. Then itself they can appeal. Okay, they can appeal. Criminal appellate jurisdiction enlarged by Parliament in 1970. So in 1970, they have made some changes. What are the changes? Reverse acquittal to life imprisonment or 10 years. So previously we saw reverse the judgment from acquittal to death. But now not death. Death is replaced by life imprisonment or 10 years. So if a person who was set free by the district court, now if he is given life imprisonment by High Court, then such cases can also be appealed. Okay. Has taken before itself a sentence, again same content, not important. So what you can do is you can ignore this content. Now whatever we discussed here, okay, just to make just to help us understand the things I have discussed, but from exam point of view, they are not going to delve to such a deeper extent. That we have to understand. Okay, that we have to understand. Some things that you have to understand, that is, so what is certificate? So whether in all the appeals certificate is required or not. So in this fashion, superficial level aspects are important. Okay, aspects are important. Appeal by special leave. Okay, so here special leave indicates. So this appeal by special leave, whether it's a power of Supreme Court or High Court, it is Supreme Court discretion. Okay, Supreme Court discretion to grant special leave. So as I mentioned, in some cases High Court should give judgment, will give judgment. After that it should also issue a certificate saying that you can appeal to Supreme Court. But if High Court is not ready to issue this certificate, but still person A, he wants to appeal to Supreme Court, then to address such kind of rare cases, so Supreme Court can grant a special leave to person A. Okay, person A. So that is special leave. Any matter passed by any court or tribunal except military court and court martial. So this appeal by special leave is not applicable to military court and court martial. Not applicable to. So it is discretionary, not claimed as a right. So no one can go and approach the Supreme Court that you have to give me, it is a right. No, it is discretion of Supreme Court. Means Supreme Court may use this power or it may not use this power, not exercise the power. So any judgment final or interlocutory. So it means even the case is being heard by High Court. So it is not necessary that Supreme Court will issue a special leave only after the final judgment. Even when the case is going on, at that time itself it can take this case by special leave. The special leave. Any matter against any court, not necessarily High Court. So when it comes to special leave, so it is not that only the cases of High Court will come to Supreme Court. Even if the case is going on in the district court also, that case can be taken by the Supreme Court. So this is appeal by special leave. Okay, special leave. So we discussed about three jurisdictions. One is exclusive original jurisdiction of Supreme Court. Then we discussed about the writ jurisdiction of Supreme Court, and then appellate jurisdiction of Supreme Court. Okay. So next, apart from that, we also have advisory jurisdiction of Supreme Court. Okay. Advisory jurisdiction of Supreme Court. So here, whenever President is under confusion, so when I say President, it is Government of India. That is central government, that is Council of Ministers headed by Prime Minister. But we will not use the term called as government, I will use the term only called as president because it has been explicitly mentioned here. So president will seek the opinion of Supreme Court. On some matter, he will seek opinion of Supreme Court. So Supreme Court will, it may give opinion or may not give. President seeks opinion from Supreme Court. Supreme Court may give opinion or it may not give opinion. Again, it is dependent on cases. In which case it should give opinion, and in which case it is not necessary for Supreme Court to give opinion. So here we have two cases. Okay, one is question of law or fact of public importance. Another is dispute arising out of pre-constitutional treaty. Okay, pre-constitutional treaty. So here keyword is pre-constitutional treaty. Question of law or fact of public importance. Now this term will cause confusion. Okay, question of law or fact of public importance. So let's take an example of a fact of public importance. Okay, for example, let's assume somewhere there is a communal violence. Communal violence in a great way. Okay, in a big way there is a communal violence. So now president wants to decide whether he has to impose national emergency or not. I am just giving an example. This is not exactly how it works. So president is under a dilemma. So what president will do? So it's a question of law or it's a fact of public importance. I am just taking an example. So in the examination, if you are getting confused, you please memorize these terms. Question of fact or public importance. Okay, public importance. So now he will seek opinion from Supreme Court. Another one is pre-constitutional treaty. So president is confused about the treaty which has taken place before independence. Let's assume 1920 Indus Water Treaty. In which year Indus Water Treaty came into force? 1956. Yes. Okay. We shall take some imaginary treaty. 1920 Karnataka Tamil Nadu Treaty Agreement. So president is confused about this thing as well. So in both the cases, first case is question of law or fact of public importance. Second is dispute arising out of pre-constitutional treaty. So in the first case, Supreme Court may tender or refuse. What does it mean? Supreme Court may say, it may give opinion, or it may say I am not ready to give opinion. Okay, even if the Supreme Court says I am not ready to give opinion also, it is okay. Okay, it is okay. But when it comes to dispute arising out of pre-constitutional treaty, Supreme Court must give its opinion. Must give its opinion. This is very important. Okay. So what we saw, president will seek opinion from Supreme Court in two cases. One is question of law or fact of public importance. Next, dispute arising out of pre-constitutional treaty. In which these two cases, Supreme Court has to compulsorily give its opinion? Pre-constitutional treaty. In case of question of law or fact of public importance, it may give or it may not give. Okay, it may not give. Let's assume Supreme Court has given the opinion. Okay, opinion in either first case or second case. In which case it is binding on president and in which case it is not binding on president? Yes. Not binding on president, not binding on president. Okay. In both the cases, whatever the advice the Supreme Court gives to president will listen, but it is not necessary that he has to follow according to it. It means it is not binding on president. So this is called as advisory jurisdiction of Supreme Court. Okay. So facilitates the government to have an authoritative legal opinion on a matter. So on some matter when government wants an exact authoritative reply, then it will ask the Supreme Court. Okay. Not important from exam point of view. So whether in the history of India such references have ever been made by the president to Supreme Court? Yes, example of such references made exist. So in the book they have mentioned about few examples in which all cases president has made a reference to Supreme Court. So those examples are not important from exam point of view. What is important here is in the history of India whether ever president has made a reference to Supreme Court or not. Okay, sought opinion from the Supreme Court or not? Yes, he has sought. He has sought. Next, Supreme Court as a court of record, a very important point here, because the majority of the aspirants, by the time they come to this page of the Lakshmikant, so they will be exhausted. So from this page onwards, generally they will skip. But UPSC will focus a question from these pages. So again, very important. Okay. So we have already seen a concept called as judicial review, right? So judicial review, it exists in which part of the Constitution? It is not explicitly present in any of the articles of the Constitution. But which article provides for the judicial review? 13. Article number 13. Okay. So while discussing this, we will come across similar such provision called as reviewing its own judgment. Reviewing its own judgment, so it will cause confusion, hence I mentioned it earlier. So Supreme Court has two powers. So Supreme Court as a court of record, it has two powers. What is that? Judgments etc. are recorded for perpetual memory and testimony, are admitted to be of evidentiary value, cannot be questioned when produced before any court, recognized as legal precedents and legal references. Okay. So this line by line is not important. What we have to understand here is, now generally you might have seen in some films and all, so whenever in high court one lawyer is arguing in front of, handling the case in front of the judge, he will quote the judgments of Supreme Court. So in high court, if let's assume some case is going on, the lawyer will say, so recently Supreme Court has given so and so judgment in such a case. Okay, he will refer it. So when such references are made, no one can question it. For example, let's assume in Karnataka High Court, so a lawyer is arguing. Let's assume Ravichandra is arguing. So Ravichandra is quoting. What is quoting? So in the Supreme Court in 1985, there was a judgment. Okay, there was a judgment. So in that judgment, they have given a judgment like this. So he will quote it. So when he will quote that judgment to High Court, he will request, you also please consider that case into account and give a similar kind of judgment. Now the judge of the High Court, he cannot say that Supreme Court might have said in 1985, but I am a judge of Karnataka High Court, I am not going to listen to the words of Supreme Court. Can he say that? No. Because once the Supreme Court gives the judgment, so it will be recorded for perpetual memory. Okay, and it will act as testimony, and it can be admitted in any court of law, whether it is High Court or whether it is District Court or Taluk Court, anyone can quote it. So that is the meaning of court of record. This line by line information is not important. Okay, not important. So one is, it is act as a perpetual memory, that is court of record. So another meaning is to punish for contempt of court. So by using the power of a court of record, it can be used as evidentiary value. It's of evidentiary value in any court. The second one is using a court of record power. Supreme Court has the power to punish for contempt of court. So if anyone, so again when it comes to contempt, there are two types of contempt. Probably discussed here. Okay, here we have. Okay. There are two types of contempt. One is civil contempt, another one is criminal contempt. Willful disobedience to any judgment, order, writ or willful breach of an undertaking given to a court. So Supreme Court will give a judgment saying that recently you have caused an accident. So person A, you have caused an accident and you have damaged some of the properties of person B. So you have to pay 1 lakh rupees to person B. So this is a judgment given by Supreme Court. Now this person A, they will give a deadline within what? Within October 30. But this person will not pay within October 30. It means he is not following the instructions of the Supreme Court. When he is not following the instructions of the directions of the Supreme Court, it means he is involved in a contempt. Contempt of what? Supreme Court. What kind of contempt? Civil contempt. So willful disobedience. So accidentally he might have forgotten, or probably he might have met in accident and he might be in hospital, that is different. But willful means deliberately, intentionally he has not given the damage charges to person B. So this is called as what? Willful disobedience. It is an example of civil contempt. Okay, civil contempt. Criminal contempt. Publication of any matter or doing an act which scandalizes or lowers the authority of a court, prejudices or interferes with the due course of a judicial proceeding, interferes or obstructs the administration of justice in any other matter. Okay. However, innocent publication and fair criticism does not amount to contempt of court. So this is the opposite of that. Now Supreme Court will give a judgment. Let's assume judgment on article number 370, judgment on GST. Now someone will write an article in the newspaper saying that whatever the judgment the Supreme Court has given with respect to article number 370, it's not correct. Supreme Court is not functioning correctly. So here, this is criticism of the Supreme Court. Now someone will make a video of the Supreme Court criticism and he will upload it in the YouTube. Again, those all examples are what? Contempt of court. But what kind of contempt? Criminal contempt. There, not following the Supreme Court orders is civil contempt. So criticizing the Supreme Court is criminal contempt. Okay, criminal contempt. So again, this line by line information is not important. Just with one example, you try to retain the content. So Supreme Court has the power to punish for contempt of court. So one important thing that we have to remember here is contempt not only of itself. If someone criticizes the judgment of Supreme Court, obviously Supreme Court will punish them under contempt of court. But here, under this power of court of record, it can punish for contempt of High Court. For example, someone criticizes the judgment of High Court. For that also, he can be punished by whom? Supreme Court. Subordinate courts. So later on we will be discussing about subordinate courts like district court and all. If someone criticizes the judgment of district court, can Supreme Court punish such person under contempt of court? Yes. Again, tribunals. Okay, we will be discussing about tribunals as well. It means under Supreme Court's contempt of court, it will not only punish for the contempt of itself, but the contempt of the High Court, the contempt of the subordinate court, tribunals as well. Okay, as well. And it extends to both civil contempt as well as criminal contempt. Okay, criminal contempt. So Supreme Court's power of judicial review. Okay. Next is power of judicial review. Already we have seen about the judicial review. Okay, judicial review. So what is judicial review? Power to examine the constitutional validity of the legislative enactments and executive orders. So first thing that we have to understand here is judicial review power, whether it extends only to legislative enactments or also it extends to executive orders as well. So if I say legislative enactment, can you give an example? Any laws can be called as legislative enactments. So what is the executive order? Implementation? Yes, implementation can be an example of executive order. For example, now Home Minister will give a direction. What is that? So police force, you become very strict in Karnataka, or he'll give an instruction to CBI. So handle all the cases only related to Karnataka because Congress government is there in Karnataka. Whereas in Maharashtra, you don't touch any of the cases because the state is being ruled by BJP. So this is what? This is an executive order. This is not a law. Now, can someone challenge this executive order in the Supreme Court saying that it is violating the Constitution? Yes, because the Constitution says that right to equality. So it is being violated. So even this executive order can be challenged in Supreme Court. Similarly, a law can be challenged in Supreme Court. So under power of judicial review, so the Supreme Court can examine the constitutional validity of both legislative enactment as well as executive order. Of whom? Of both central government as well as state governments. Not only of central government, both central as well as state government. Okay, state government. If found to be violative of the Constitution, Supreme Court, after studying the legislative enactment or after studying the executive order, if it finds that it is violating the Constitution, it is not as per the provisions of the Constitution, then what it can do? Such a law or such an executive order can be declared as illegal, unconstitutional and invalid, okay, by Supreme Court. By Supreme Court. So consequently, once such a law has been declared as invalid, once such an executive order has been declared as invalid, it cannot be enforced by government. After the Supreme Court declaring it as invalid, so government cannot go forward and start implementing that law or start implementing that executive order. Okay, executive order. So why is this requirement of judicial review? To uphold the principle of supremacy of the Constitution. So who is supreme in India? People of India or Constitution? Yes. To uphold the principle of supremacy of the Constitution. To maintain federal equilibrium. So how federal equilibrium will be maintained? We have seen If center tries to make a law on the state list subject, so it will become a threat to federalism. So to stop such kind of threats, so Supreme Court can use the power of judicial review. If center makes a law on the state list subject, then Supreme Court will go for judicial review. So saying that the law made by you is not adhering to the constitution. Why it is not adhering? Because you are making a law on a subject which belongs to state list. Okay, state list. To protect fundamental rights of citizens. So we also require the power of judicial review to uphold the fundamental rights. Okay, to uphold the fundamental rights. If a law made by Parliament, if it violates any of the fundamental rights, then such a law will be declared as invalid by Supreme Court. In this fashion, it will uphold or protect the fundamental rights of the citizens. So whether Supreme Court has used the power of judicial review? Yes, it has used the power of judicial review in multiple cases. So just two I have quoted here: Golaknath case and Keshwanand Bharati case. Okay, Keshwanand Bharati case. Judicial review phrase, though nowhere used in the Constitution. Okay, it is nowhere used in the Constitution. The provisions of several articles explicitly confer the power of judicial review on the Supreme Court. If you read the various articles of the Constitution, you will get to know that there exists a power of judicial review on the Supreme Court, okay, with the Supreme Court. Constitutional validity can be challenged on three grounds. So whether any law or executive order, whether it is violating the Constitution or not, how you will get to know? First, if you will check whether the law takes away the fundamental rights. Infringes means takes away the fundamental rights. If a law or executive order, if it takes away the fundamental rights, then we can say that the constitutional validity is being failed by a particular law or executive order. If it is outside the competence of the authority, for example, if center makes a law on the stateless subject, repugnant to the constitutional provisions, generic, just leave it. Scope of judicial review in India. Scope of judicial review in India. So here there are some things which are very confusing. So in one go you may not be able to connect all the dots. So gradually again we will be discussing one by one. So scope of judicial review in India is narrower than that of what exists in USA. It means the judicial review scope is wider in India or USA? USA it is wider. So how is it wider? We shall look into it. American Constitution does not explicitly mention about it. American Constitution also explicitly does not mention about the term judicial review. Again, question can be framed in prelims. How they can frame a question? The term judicial review is explicitly mentioned in the American Constitution, whereas it is not in the Indian Constitution. True or false? False. In both Indian Constitution as well as American Constitution, there is no explicit mention of the term called as judicial review. Okay, judicial review. But the scope of judicial review is more in which country? USA. Okay, America. American Constitution provides for due process of law. So this is very important. I think during the discussion of fundamental rights also somewhere we came across this term, due process of law and procedure established by law, probably while discussing article number 21. Okay, so I urge you to go back to that class related video once again to connect these two dots. So due process of law gives wide scope to Supreme Court to grant protection to the rights of its citizens. Declare violative not only on substantive grounds of being unlawful, but also on procedural grounds of being unreasonable. Okay, while discussing about article number 21, we have discussed. So what does it mean? Due process of law. So in India, what is the job of the courts? Just to study that whether the law is being followed properly or not. Okay, in case what happens is, we shall take an example. So Labour Act 2025. Labour Act 2025. So in Labour Act there are, let's assume there are various sections, section 1, section 2, section 3 and so on. Somewhere we have section 50. So section 50 says that a person can be employed for 12 hours a day. Let's take not 12, 15 hours a day. So there are 24 hours. In that 24 hours he can be made to work 15 hours a day. So this is Labour Act of 2025. Now a person working in a factory, let's assume person A, and this factory name is, let's assume, company X. So company X, it owns a factory, so this company X, so there a person is working called as A. Now he is being made to work for 17 hours a day, for 17 hours a day. Now this person or someone on behalf of person A, they will go and file a case in the court. Okay, they will file a case in the court, let's assume Supreme Court. Now Supreme Court will study, so whether he is being made to work for 17 hours, so by various cameras and all that video footage, they will come to know that he is working 17 hours a day. Now what the Supreme Court will do, it will study this law. So in this law, what has been written? 15 hours a day. So he is being made to work 17 hours a day. It means company X is violating which law? Labor Act 2025. So this company will be given a punishment. It may be in terms of what? Fine or something. Fine, or it may even give a jail sentence to its CEO. Okay, to its CEO. Now what the court is doing? It is following the procedure. Now let's assume another person B is there. He is being made to work 14 hours a day. Okay, 14 hours a day. So he will also feel tired. For 7 to 8 hours of working, he will feel tired. So one day what he will do, he will think of filing a case in the Supreme Court. He will go to Supreme Court and he will say, my factory owner is making me to work 14 hours a day. So I am really tired, I cannot work. But I cannot leave this work also, because if I go back, then I have to, I am the only breadwinner of the family. My family requires that I have to work. So when he files a case in the Supreme Court will study this law. So after studying the law, Supreme Court will see that section 50 says 15 hours a day. So already it is mentioned and they are making you to work 14 hours per day. So it means company is not violating the law. Okay, not violating the law. So company will say, we are not going to punish company X, so you have to work 14 hours per day. So why it is so? Because in India, it is procedure established by law. Whatever the law says, so Supreme Court and High Court will work according to it. Okay, according to it. Now when we say due process of law, as per the American Constitution, so it will not only challenge the law on the grounds of being unlawful, unreasonable. So as human beings, we know that maximum a person can work. Now forget about the UPSC aspirants. You all read about 15 hours per day. Okay, that's different thing. Because you'll be sitting in a room and you'll be reading. That's a different thing. But a person who is working in a factory, it's quite different. So I hope all of you read minimum 15 hours, right? Okay. So now a person who is working in a factory, for him more than 8 or 10 hours, it will be difficult for him. So when he challenges in the US Supreme Court, even if the law says that 15 hours per day, US Supreme Court will say this 15 hours per day is unreasonable. It is unreasonable. It has to be reduced to 8 hours. Okay. So that is called as due process of law. So when it comes to power of judicial review, so that's why we say the American Constitution, the American Supreme Court, the judicial review power is wider in USA as compared to India, because it follows what? Due process of law. Okay, due process of law. So just to make you understand, I have given this example. This example is not important, but they asked question on this. Again, I will show you the question as well. So it is, USA is due process of law. Indian Constitution, it says procedure established by law. Supreme Court examines only the substantive question, that is whether the law is within the powers of the authority concerned or not. It is not expected to go into the question of reasonableness, suitability or policy implications. So Supreme Court will not go into detailed aspects whether the law is correct or not, but they will check only whether the law is being followed properly or not, whether that law is as per the Constitution or not. Only that's it. Okay. The American principle of judicial supremacy. Okay. So in America, they have principle of judicial supremacy. Whether in India we have a principle of judicial supremacy? No. In India, neither parliament is supreme nor judiciary is supreme. So it's a synthesis. So America, we have a system of judicial supremacy. In India, it is recognized in our constitutional system, but to a limited extent. We too have judicial supremacy, but not to the extent that exists in USA, to a limited extent. So these things you have to memorize from exam point of view. So if they give you about 2 to 3 countries, and if they ask you which country has judicial supremacy, UK, India or USA? Okay, USA. British principle of parliament supremacy, we have discussed this. I think during the discussion of parliamentary system, we do not fully follow it. So we do not have complete parliamentary supremacy. Yes, we have seen, right? What are the limitations on the sovereignty of parliament? We have discussed these points under which topic? parliamentary system. Okay, so written character of the Indian Constitution. So because of that, Parliament cannot make law as per its whims and fancies. Next, federalism with division of powers. So Parliament cannot make a law on the stateless subject. Fundamental rights. Parliament cannot make a law by taking away the fundamental rights. Next, judicial review. So all these are the things which impose restriction or limits on the sovereignty of the Parliament. So here in India, what exists is a synthesis of both. What is that? American principle of judicial supremacy to some extent, British principles of parliamentary supremacy to some extent. Not Parliament is neither completely supreme nor judiciary is completely supreme. So India is a synthesis of both. When it comes to parliamentary supremacy, it is Britain. When it comes to judicial supremacy, it is USA. So India is a synthesis of both. Synthesis of both. So next, other powers of Supreme Court. So we discussed about what? Exclusive original jurisdiction, writ jurisdiction, appellate jurisdiction, advisory opinion, court of record. Next, judicial review. Okay, judicial review. Next, other powers. It decides disputes regarding election of president and vice president. Already we have seen while discussing the topic of president and vice president. Whenever there is a discrepancy with respect to the election of president and vice president, where the case will take? Supreme Court or High Court? Yes, Supreme Court. When it is election dispute related to election of members of Lok Sabha or Raj Sabha, High Court. Okay, High Court. Next, these disputes, original, exclusive and final. Election of president, election of vice president, so it is original, only Supreme Court can hear it. Exclusive, sorry, original means exclusive, only it can hear it, and original means first instance, and whatever the decision it gives, it is final, it cannot be challenged. Next, UPSC, chairman plus members. Again, we will be discussing a separate topic called as UPSC. So, inquire into conduct and behavior, references made by president. Okay. So, president will receive some kind of complaint saying that UPSC chairman or member is involved in fraudulent behavior. Okay, this is not true, but let's assume someone makes a complaint to president. So, now what president will do? Before taking an action, he will make a reference to Supreme Court. What he will tell to Supreme Court? I have received a complaint that chairman and members of UPSC, they are involved in some unwanted activities. So please study and report back to me. So Supreme Court will inquire into the matter and into conduct and behavior of members and chairman of UPSC. Now finally what they will do? They will give recommendations to president. So if they have committed mistake, then they will say, yes, they have committed mistake, remove them. If they are innocent, then they will say, they are innocent, don't do anything to them. So whatever the report the Supreme Court will give to president, if the Supreme Court says that, yes, they are guilty, they have to be punished, then what president will do? If found guilty, recommendation to president binding. If whatever the recommendation the Supreme Court gives to president, it will be binding on president. This is very important. In the previous cases, when references were made by when opinion was sought by president from the Supreme Court, whatever the opinion it gave, it was not binding. But in this case, after studying whatever the opinion the Supreme Court gives, it will be binding on president. It will be binding on president. Okay. Review its own judgment or order. So review its own judgment means previously one judgment has already been given. Can you take a different stand later on? For example, today we will say that yes, he has committed mistake. After few days he will say that no, I have gone through the documents once again, I have understood that he has not committed the mistake. So whatever the judgment you have given previously, that judgment can be changed. That is called as reviewing its own judgment. Whether Supreme Court can review its own judgment? Yes. Example, whatever the judgment it gave in Keshwanand Bharti case, it departed from its previous judgment of Gorakhnath case. Means whatever the judgment it had given in Gorakhnath case, so it changed that judgment and it gave a different judgment in Keshwanand Bharti case. From this we understood that what? Supreme Court can review its own judgment. So reviewing its own judgment is different from judicial review. Okay, judicial review. Withdraw cases pending before High Court and dispose them by itself. So some cases which are present with the High Court, so even final judgment has not been given by High Court, but even when it is in the hearing stage itself, Supreme Court will take the case by itself and it will give a final judgment. So that power also Supreme Court has. Transfer a case or appeal pending before High Court to another High Court. So let's assume there is a case which is pending in Kerala High Court. This case can be transferred to Karnataka High Court. Transfer a case or appeal pending before High Court to another High Court. Its law is binding on all courts in India. Its decrees or orders enforceable throughout the country. All authorities in the country should aid in the Supreme Court. So Supreme Court, whatever the judgment it gives, so all should follow that judgment. Okay, all should follow the judgment. So all the authorities should help the Supreme Court in this matter. For example, the orders given by the Supreme Court, if anyone is not following properly, so for example, let's take police force. So it will make sure that people are following that order because that order has been given by Supreme Court. So again, you ignore this point. So just all the law made by Supreme Court is binding on all courts in India. Ultimate interpreter of the Constitution, we know it. Power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory. So apart from Supreme Court, we have many courts, high courts, tribunals, district court and all. So ultimate control on all these courts lie with the Supreme Court. Okay, Supreme Court. Supreme Court's jurisdiction and powers with respect to matters in the union list can be enlarged by Parliament. Okay. Now we have union list. So union list, how many subjects are there? 100. So let's assume 1 to 60 and 61 to 100. So initially let's assume Supreme Court can hear cases only related to these 60 matters. Now we want to make Supreme Court powerful to hear the cases related to these matters as well. So when you give more powers to the Supreme Court, that is called as enlargement of the jurisdiction. Who can do this enlargement? Parliament. Supreme Court's jurisdiction powers with respect to matters in the union list can be enlarged by Parliament. Supreme Court's jurisdiction powers with respect to other matters apart from the union list. Which are the other matters? State list and concurrent list. So such matters can be enlarged by a special agreement of the center and the states. Exact procedure they are not given. So when it comes to union list, only Parliament can enlarge. When it comes to other matters, center and states, they have to sit together and they should decide how much powers have to be given to Supreme Court. Okay, Supreme Court. Next, Supreme Court advocates. So who are advocates? Who practice in the court of law, especially Supreme Court. So Supreme Court advocates are those who are entitled to practice law before Supreme Court. So all people are not allowed to practice in front of Supreme Court. Only there are few people who have been identified as Supreme Court advocates, so they can practice in Supreme Court. So again, they have been classified into senior advocates and advocates on record. Senior advocates and advocates on record. So who gives this designation? Senior advocate is a designation given by either Supreme Court or any High Court for those deserving such distinction. So not everyone will be given an status of senior advocate. Only few will be given, and who is going to give this status? Supreme Court or High Court. Okay, deserving such distinction. So what are the criteria required? They are not mentioned and hence not important. Okay. Are not entitled to appear without an advocate on record in the Supreme Court or without a junior in any other court or tribunal in India. So in Supreme Court, when a senior advocate goes for arguing, he cannot go alone. Along with him, there should be another person called as advocate on record. Okay. So in Supreme Court, whenever he is arguing, so senior advocate should be there. Along with him, compulsorily there should be an advocate on record. So who is advocate on record? We will not go into detailed aspects. Now, when senior advocate is appearing any other court, for example, High Court or District Court or any other court, so along with senior advocate, there should be a junior person as well, junior advocate. Okay, junior advocate, while hearing or while arguing for any other case in any other court or tribunal. So not that an important information. Okay, you can just completely ignore it. Advocates on record, only they are entitled to file any material or documents before the Supreme Court. So in Supreme Court, when you are hearing a case, you have to submit some kind of documents and all. So that documents can be submitted by advocates on record. Senior advocate cannot submit the documents. Okay, cannot submit the documents. Other advocates. So advocates whose names are entered on the roll of any state bar council maintained under the Advocates Act 1961. So after completing the 4-year law graduation, law degree, so person will not automatically get entitled to practice in law. He has to register his name. So where? He has to register in a what? State bar council. So we have multiple bar councils. So here bar indicates what? Under the court's context. Okay. So we have state bar council, we have what? Supreme Court's bar council. We will be discussing about them later on. So once if a person wants to practice law, then he has to register his name. He has to register his name. So under which act? Advocates Act 1961. So whether it is State Bar Council or Central Bar Council, so it is administered by only one act, that is Advocates Act 1961. They can appear and argue any matter on behalf of a party in the Supreme Court, but they are not entitled to file any document or matter before the court. So here there is a bit confusion, so we will not go into deeper aspects. Okay. So they can appear and argue in any matter in any court, but they cannot file any document. Who can file the document? Advocates on record. Okay, advocates on record, not senior advocates. So we completed with the discussion of the Supreme Court. So first we started with the match the following, wherein we compared the provisions of Supreme Court and High Court simultaneously. Next we discussed some of the important Supreme Court provisions which we had missed while discussing with the help of match the following kind of thing. So now we will be discussing about the High Court. Okay. So highest court of appeal in a state. So it is also a protector of fundamental rights of citizens like Supreme Court. Vested with the power to interpret Constitution. So whether it can interpret the Constitution, High Courts can also interpret the Constitution. But who is the highest interpreter of the Constitution? Supreme Court. Have a supervisory and consultative roles, which we will be discussing later on. Not that much important. Superficially you understand that. So whether High Court has a supervisory role? Yes. So where supervisory? Below the High Courts we have district courts and other courts. On them it has a supervisory role. Okay. And consultative roles not important from High Court. In case of Supreme Court is important, but here it is not that much important. You can just ignore it. So whether High Courts of India have jurisdiction over revenue matters related to taxes and all? Yes, they have. So even if you are not able to connect also, just understand from this fashion. Whether High Courts have jurisdiction over revenue matters? Yes. Pre-Constitution era, it was absent. It means before 1950, High Courts existed. In 1862 itself we have High Courts. But in those days, whether High Courts had the power of jurisdiction over revenue matters? No. After 1950, High Courts got power over the revenue matters. Other additional powers conferred by the Constitution. Writ jurisdiction. We already discussed with respect to Supreme Court. Next we will discussing with respect to High Court. Power of superintendence, consultative power. So these are all generic nature. We will be discussing later on. Constitution has empowered both Parliament and state legislatures to change the jurisdiction and powers of High Court. So when we say change, whether we can give more powers? Yes. Can we curtail the powers? Yes. Yesterday we have seen even powers can be curtailed on matters mentioned in the Constitution or not mentioned in the Constitution. Not mentioned in the Constitution. So when it comes to Supreme Court, only powers can be enlarged. By whom? By Parliament. Can they be curtailed? They cannot be curtailed. But in case of High Court, it can be changed. It means it can be either increased or it can be curtailed. Okay, it can be curtailed. So following jurisdiction and powers. Now here when it comes to examination, exam point of view is very important. Because there is so much of content we have to understand. When it comes to original jurisdiction and all, UPSC often focuses on Supreme Court and very rarely on High Court. So we have to prioritize the things. Okay, very important. We have to prioritize. So what is that? So original jurisdiction of Supreme Court is very important, but original jurisdiction of High Court is not that much important. Okay, not that much important. So original jurisdiction of High Court, it can hear marriage related to issues related to marriage as well as will. Okay, so directly Supreme Court can hear it. High Court can hear it. Next, election disputes of MPs and MLAs and MLCs. So whenever there is an election related dispute with respect to president and vice president, it is Supreme Court. When it comes to MP, when it comes to MLAs and MLCs, it can be heard by High Court. So it means election disputes of MPs, it cannot be heard by district court. It cannot be heard by district court. Revenue matter, fundamental rights enforcement. Okay. It can transfer subordinate court to own file interpretation of the constitution. So again, not important, just leave it. So when it comes to district court or any other court, if they are not able to give a proper judgment because of the constitutional matters, it can take to itself. So what I will urge you, just ignore this point. Just ignore this point. Calcutta, Bombay, Madras and Delhi High Courts have original jurisdiction in case of higher value. Just ignore this also. Okay, just ignore this value. So already we have discussed about the writ jurisdiction of Supreme Court, and there we saw that the writ jurisdiction of Supreme Court is wider or High Court is wider? High Court is wider. So article number 226 deals with the writ jurisdiction of High Court for enforcement of fundamental rights and any other purpose. Okay. So can issue to any person, authority and government not only its territorial jurisdiction but also outside its territorial jurisdiction if the cause of action arises within its territorial jurisdiction. So here, okay. When it comes to High Court's writ jurisdiction, it can issue to a person not only who is present in that particular state. Let's assume Karnataka. It can also be issued to a person who is present outside state. For example, someone has committed a murder in Karnataka and he has gone to other state. Let's assume Tamil Nadu. So even a writ can be issued against him as well. Okay, him as well. Concurrent with the writ jurisdiction of Supreme Court. So both Supreme Court and High Court can issue writs with respect to the same matters. That is violation of fundamental rights. Article number 32 deals with the writ jurisdiction of Supreme Court. Article number 226 deals with the writ jurisdiction of High Court. So this point is important. Which one has a wider jurisdiction when it comes to writs? High Court has a wider jurisdiction when it comes to what? Fundamental rights or writs. Sorry, not fundamental rights. High Court's writ jurisdiction is wider than that of Supreme Court. So in Chandra Kumar case 1997, Supreme Court ruled that it forms the part of the basic structure of the Constitution. So the writ jurisdiction of the High Court, it forms a basic structure of the Constitution. So it was declared in Chandra Kumar case, not important from Plim's point of view. In mains point of view you can quote, but from Plim's point of view maximum what they can ask is whether writ jurisdiction of High Court, it comes under the basic structure of the Constitution. Yes. So in which article do we have the term called as basic structure? No. So through which judgment we came across the term called as basic structure? Keshwanand Bharti case. Okay, Keshwanand Bharti case. So what we will do when it comes to High Court, that is appellate jurisdiction. Okay, we will not go through any of this content, and I will also urge you not to go through this. Okay, not important, because again here exams demand is very important. Supreme Court, it's an important body. We saw, even though it is not important also, we discussed about the appellate jurisdiction in detail. Now here we will not even discuss, and I will urge you not even to go through it. Unnecessarily it will lead to confusion. Okay, it will lead to confusion. So it can hear matters, it has appellate jurisdiction with respect to civil matters. So I will ignore all these points. So Bombay, Calcutta, Madras, all these things you will ignore. So if you think that you need to go through this content, when you will go through this content? When you have completed the entire syllabus of polity, geography, history, economics, science and technology, environment, art and culture, international relations, then you have a surplus time. Okay, probably in the month of May. When you have completed all the topics of all the subjects, then when you have surplus time, whichever you have skipped, you can go through this content. Until that point, you will just ignore it. Okay, you will ignore it. Because what happens once you start reading, you will start gaining interest. So this is what happens. Majority of the aspirants, when you ask them a favorite subject, their favorite subject will be polity. Okay, their favorite subject will be polity, because every time they read, they will be understanding few points based on the basic information which they have, and that keen interest which they will build in polity. So they will spend too much time on polity, ignoring other subjects. So that should not happen. So polity, okay, sometimes it will be 10 questions, sometimes 15, it's okay, but only using polity alone you cannot crack the prelims. So you need to be jack of all the other subjects as well. Hence you need to understand the prioritization, so which has to be given higher priority, which has to be accorded lower priority, and this cannot happen at the time of examination. From now itself that approach has to be built. Okay, that approach has to be built. So we will completely ignore this matter. This one point you just again in current affairs also will come. tribunals. We'll be discussing about different tribunals. Okay, tribunals are also something similar to courts itself, but in courts we have only judges. But in tribunals, apart from judges, we also have experts. For example, if we take National Green Tribunal as an example, so in National Green Tribunal, apart from what judges, there will be people who are experts in environment related matters. So they are called as tribunals. So tribunals, division bench of the State High Court said that tribunal subject to writ jurisdiction of High Courts, no direct appeal to Supreme Court without going to High Court. So some tribunal will give a judgment. So there are two options for tribunal. Either it can be appealed in High Court, and if you are not satisfied with the High Court, then you can go to Supreme Court. Okay. So in one judgment they have said that you cannot directly go to Supreme Court without going to High Court. But again, from current affairs point of view, it's not important. Why? Because in current affairs we'll see in some agencies directly you can file an appeal from a tribunal to a Supreme Court, and in some cases you have to file an appeal to High Court and then it will go to Supreme Court. So from that context, again, it should not cause confusion. You just leave this matter as well. So similarly here, you ignore all these things, just retain the content that in case of civil criminal matters also, High Court can exercise what jurisdiction? Appellate jurisdiction. Okay, appellate jurisdiction. Supervisory jurisdiction of High Court. So power of intendance over all courts and tribunals functioning in its territorial jurisdiction, a broad power extends to all, whether they are subject to the appellate jurisdiction of High Court or not. Administrative superintendence plus judicial superintendence. Regional jurisdiction can be suo motu on its own. However, it does not vest with any unlimited authority, sparingly used in appropriate cases. So here on all these points, you just focus on this point. Administrative and judicial superintendence. Rest all the points, you just ignore it. So administrative superintendence means, so where the taluk court should be established, in which place, where the district court should be established, how many judges should be there, and to a particular court, district court, how much money we have to allot for tea, how much we have to allot for coffee. So these are all what administrative superintendence. Next, judicial superintendence, which judge should hear which case. Okay, so these are all what judicial superintendence. So when it comes to supervisory jurisdiction of High Court, it consists of both administrative superintendence as well as judicial superintendence. So all the other things we just ignore it. Okay, just ignore it. So it has control over all the courts and tribunals which lie within the state. Okay, within the territory of that state. Here one more is this suo motu. It comes also in other cases as well. So suo motu means on its own. So some cases, what it can do is, it can take on its own. Now generally how the cases are registered, someone will file a case in the court. Without a case being filed in the court, it will understand the situation and it will initiate a case by itself. That is called as suo motu. Okay, suo motu. So again, it does not mean that it has unlimited authority. Again, its authority is limited. Okay, again, not important. Here we will see few things, because again the things will be connected with subordinate courts. Once we discuss, once we start discussing about the subordinate courts, it will become important. In addition to appellate and supervisory jurisdiction, administrative control over them, so consulted by governor in the appointment of judges. Okay, so now how we will retain this content? Who is going to appoint the judges of the district court? We know Supreme Court, we know High Court. Who will appoint the judges of the district court? It is governor. Okay, so governor, while appointing the district judges, he will consult whom? He will consult the High Court. He will consult, in addition to appellate and supervisory jurisdiction, administrative consulted by governor. So governor will consult the High Court when he is appointing district judges. Okay, it may be appointment, or it may be promotion, or it may be posting. Okay, it may be posting. Next, judicial service of state appointments other than district judges. So other than district judges, let's assume taluk judges and all, then also governor when appointing, he will be consulting what? High Court. Okay, High Court. So matters of judicial service. So for example, posting, promotion for all the judges. So what High Court deals with it, not important, just leave it. So whatever we have seen in the Supreme Court, whatever the pending cases are there in the High Court, those cases can be taken by Supreme Court. Similarly here, whichever cases are pending in the district court, that can be taken by High Court and disposed by themselves. So not important, just leave it. So its law is binding on all subordinate courts, again not important. When we say higher authority Supreme Court, its law is binding on all the lower courts. Similarly, High Court is the highest court in a state. So whatever the judgment it will give, whatever the rules and regulations it will make, it will be binding on all the lower courts. Okay, lower courts. So this is very important. High Court as a court of record. Okay, so there we saw a Supreme Court as a court of record. So what were the various powers which the Supreme Court enjoyed as a court of record? Perpetual memory. Whatever the judgments the Supreme Court will give, so it will be in perpetual memory. Anyone can quote this judgment in any court of law. That is one. Next. Yes. So it can. There is a contempt of court. That also comes under court of record. Next. Power to review its own judgment. That also comes under court of record. Okay, court of record. Evidentiary value. Any subordinate court. Here also, when High Court gives a judgment, that judgment can be quoted in Supreme Court. Whatever the judgment Supreme Court gives, that judgment can be quoted in High Court or in District Court also. My question is, when a High Court gives a judgment, okay, that judgment can it be quoted in Supreme Court? No, it cannot be quoted in Supreme Court. It can be quoted in the lower court, like District Court and all. Okay. Punish contempt of court. So can Supreme Court punish for the contempt of court? Yes. Similarly, High Court can also punish for contempt of court. So simple imprisonment of fine, not important. We'll leave it. Okay. Not defined by the Constitution. This is very important. Whether the term contempt of court is defined in the Constitution, very important. It's not defined. Now we have seen various terms, right? Like judicial review. The term judicial review is not defined in the Constitution. Next, basic structure is not defined in the Constitution. Similarly, the term contempt of court is not defined in the Constitution. So what does it mean? They are not defined. So where do we find the definition of contempt of court? The term contempt of court is present, but it is not defined. Okay, it is not defined. So for example, okay, again we shall not get confused. The term judicial review is not present in the Constitution. Okay. The term office of profit is present in the Constitution? Yes, it is present. Whether it is defined? No. Similarly here, the term contempt of court is present in the Constitution, but it is not defined. So where do we find the definition of contempt of court? Contempt of Court Act 1971. Here we find the contempt. So previously we saw the definition of civil contempt and criminal contempt, right? So if a person does not obey the orders of the court, so what kind of contempt it is? Civil court or criminal contempt? Civil contempt. Okay. So if he criticizes the court's order through a newspaper article or a YouTube video, it will be criminal contempt. So those definitions are present in Contempt of Court Act of 1971. So fair criticism and publishing do not amount. So whenever criticizing in a very fair manner, it should not be considered as what? Criticism. Again, it will lead to confusion. Just leave this point. Okay. So power to review and correct its own judgment or order or decision. So now it is not judicial review. Previously, whatever the judgment it has given, if it thinks that that judgment was not proper, can it correct the judgment? That is called as reviewing its own judgment. So can High Court do the same? Yes. So even though no specific power of review is conferred on it by the Constitution, so High Court, whatever the judgment it has given, it can change, it can reverse, it can review the judgment. But whether this provision is explicitly mentioned in the Constitution? No. Even though explicitly it has not been mentioned in the Constitution, but High Court enjoys the power to review its own judgment. Okay, power to review its own judgment. So even the Supreme Court and High Court, they enjoy the power of judicial review. Whether the term judicial review is explicitly mentioned in the Constitution? No. Similarly here, even though explicitly it has not been mentioned, okay, but still the High Court, what it does, it has the power to review its own judgment. Supreme Court on the other hand has been specifically conferred with the power to review by the Constitution. Very important. We are discussing about this very important point. Power to review its own judgment. Whether Supreme Court also has, whether High Court has, yes. So to Supreme Court, whether Constitution has been explicitly conferred, Constitution has explicitly conferred the power. Yes. Again, we will not go into detail like which article and all. Whether High Court has been explicitly conferred with this power? No. So both Supreme Court and High Court have the power to review its own judgment. Supreme Court has been explicitly given power by the Constitution, whereas High Court has not been given explicitly that power by the Constitution. So this is very important point. Now see here, this is different. High Court's power of judicial review. So now in the examination, if they ask you, so High Court's power to review its own judgment, so derives from which point? Court of record. From court of record, it has various provisions. One is contempt of court, another one is power to review its own judgment. Next, High Court's power of judicial review can examine constitutionality of legislative enactments and executive orders. You can compare it with that of the Supreme Court, both central as well as state government. So it has the power of judicial review with respect to both central laws as well as state laws, with respect to center's executive orders, with respect to states' executive orders. Term not present in the Constitution, judicial review. But provisions of article number 13 and 226 explicitly confer the power on the High Court. When you read article number 13 and 226, you will understand that High Court has the power of judicial review. So from exam point of view, if they ask, the judicial review power has been conferred on the High Court explicitly, true or false? Okay, the power of judicial review has been explicitly conferred on the High Court by the Constitution. Okay, it's true. The power to review its own judgment has been explicitly conferred on the High Court by the Constitution. False. The power of judicial review has been explicitly conferred on the Supreme Court by the Constitution. True. The power to review its own judgment has been explicitly conferred on the Supreme Court by the Constitution. Okay, so these things are very important. Constitutional validity of central laws, 42nd Amendment, 40 not important, just challenge grounds same as Supreme Court. Okay, so what are the grounds on which you can challenge legislative enactment or executive orders to High Court? Same as that of Supreme Court. So which are the grounds? Can you recall? Fundamental rights are violated when a center makes a law on the state list subject. So these are the same grounds which are discussed under Supreme Court. So clearly, I think we came to the end of the topic itself. So here I compiled this list to indicate the state and the corresponding High Court. Okay, again this list is important. So first, if they ask you a question, how many High Courts are there in India?
25.
Okay, so first we need to have that clarity. So we have 25 High Courts. First level of question, how many High Courts are there in India? 25. Okay, 25. So the name of the High Courts: Allahabad High Court, jurisdiction is Uttar Pradesh. Andhra Pradesh High Court, Andhra Pradesh. Okay. Next, Bombay High Court. So it has jurisdiction over so many areas: Maharashtra, Goa, Dadra and Nagar Haveli, and Daman and Diu. Now they have been united. Okay. So next, Kolkata High Court, West Bengal, Andaman and Nicobar Islands. Chhattisgarh. Name of the court is also Chhattisgarh High Court. Jurisdiction also Chhattisgarh High Court. Delhi, Guwahati, Assam, Nagaland, Mizoram, Arunachal Pradesh. Okay, 4 states. Gujarat, Himachal Pradesh, Jammu and Kashmir and Ladakh. Jharkhand, Karnataka, Kerala High Court, Kerala and Lakshadweep. Madhya Pradesh, Madras, Tamil Nadu and Puducherry. Manipur has its own High Court. Meghalaya has its own High Court. Odisha has its own High Court. So Bihar, we call this Patna High Court. Next, Punjab and Haryana. So there is a common, we call this Punjab and Haryana High Court, which is common for Punjab, Haryana and Union Territory of Chandigarh. So Rajasthan High Court. Sikkim has its own High Court. Telangana, so recently created, Telangana has its own High Court. Next, Tripura High Court. Uttarakhand High Court. There are 24 High Courts in India. 25. So year not important except oldest. So here in the exam, in the book, what they have mentioned is they have given the year of formation of each and every High Court. That year of formation is not important. Just out of curiosity, oldest. So which is the oldest High Court among these? Madras, Calcutta Bombay. Only we'll focus on these things. Okay, oldest high courts. Seats not important. So some high courts, for example, if you look at Karnataka High Court, so apart from Bangalore, a seat is also established at Dharwad. So those things are not important. Hence, I have not mentioned them. Seats not important. So out of curiosity, I have added high courts with jurisdiction over more than one state. More than one state. So Punjab and Haryana High Court. So which are they? Punjab, Haryana and Chandigarh. Guwahati High Court. Arunachal Pradesh, Nagaland, Mizoram is there. Next, 23. 4. Which are they? Assam, Arunachal Pradesh, Nagaland, Mizoram. Next, Bombay High Court. Nagar Haveli. Okay. So high courts with jurisdiction over more than one state or union territory. So again, the same list. So these are the 7 such high courts. So Punjab and Haryana High Court we saw, Guwahati High Court, Bombay High Court, Madras High Court, Jammu and Kashmir High Court, Kerala High Court. So which is the other jurisdiction of Kerala High Court? Lakshadweep. West Bengal, Andaman and Nicobar Islands. Okay. So with this we have concluded with the topics, 2 topics. One is Supreme Court and the other one is High Court. Okay, High Court. So wherever I mentioned that ignore those points. So I'll urge you to ignore for a time being. Otherwise, again, you'll be stuck there itself. You will not be able to make progress to the next topic. Okay, next topic. So with this, we shall conclude the topics called as Supreme Court and High Court.